resident in Jersey for nearly 40 years. I feel like a bit of a jack of all trades because I'm a qualified public sector accountant. I'm also qualified in financial services compliance. I've been a civil servant for 25 years and a state politician. I've also done a little work in all the Channel Islands, both in Guernsey on planning matters and in Alderney. And I think a particular point is that I was the civil servant heading up the whole P&E planning environment team for 13 years. And I think some of these, I can offer some background which will help, I think, your decisions, sir. As a States member, when I was a States member from 2011 to 2014, I was always very concerned as chair of the Environment Scrutiny Panel that the site selection process for the hospital was an open, transparent and consultative one with the public. In fact, during that time, I did secure political commitments that would be the case. I also entirely accept the need for a new hospital because I was in fact Director of Finance and Clinical Information at the hospital for 3 years, from 88 to 91, ironically, when at the time the current building fronting the parade was built, and part of that admin team. There's no question in my mind that since that time Jersey has changed dramatically. We've had a huge increase in population, and I think health service needs have actually completely transformed clinical needs. I think the challenge is to get that hospital that we can all be proud of that meets our need. This site is absolutely far too small. I've sat through the inquiry for 3 days and I've done that because I wanted to get into the issue, having been working at the island for 2.5 years. I wanted to, and not having an opportunity to get into all of the issues in the applicant's submission, I wanted to check those out. The impressions I'm left with is what we're faced with here is a moving target application. And if I were a private, would we allow, I ask, a private developer this extent of latitude where we can have last-minute amendments to a planning application submitted during the middle of a planning inquiry, well beyond the closing date for advertising in accordance with the law, and then still, in the middle of a planning inquiry? If this was a private developer and this weren't an inquiry, there would automatically be a deferral of decision-making process, an adequate time for consultations and discussions and rework to go on. Now, we haven't, and also I can tell you as a private applicant who has just got permission for rebuilding a new kitchen on the back of my house, I want to move a wall 2 metres, it's only a single-storey wall, and I've been told I've got to put in a new application, pay a new fee, and wait 8 weeks. Now, is this the standard? What's our standard for the way in which we allow the states to basically drive a coach and horses through proper due process in the planning system? Just look at the dates. Application validated 19th of July. Notice of advertisement 25th of July. Note of the closing date for the inquiry, 9th of September, extended to the 27th of September. Looking at the application, we've got 5 crucial statements lodged on the 18th of October. Those 5 statements are all about this planning envelope, this Rochdale envelope, crucial, we've heard, and we've heard 3 days about it, submitted after those due publication dates under the law. And then what do we get? We get a further revision that's not even on the planning website that was issued on the 3rd of November, which apparently is going to be the basis of consideration. This is real moving target stuff. The rules on statutory advertising have not been complied with. I think this is disrespectful to the inquiry, disrespectful to the planning process, which the people of this island depend on and rely on its integrity. Planning issues are contentious. In a small island, we all need everybody to work to the procedural rules. That has not been so. But there are other process issues. We have, Jersey is again a very small place. We don't have the capability of being able to evaluate environmental impact assessments ourselves. But we do have, very late in the day, we adopted subordinate legislation to put that within the power of our planning laws, that major applications of this nature should have an impact assessment. Part of that rules requires, and it's a statute, it says a minimum requirement, any environmental impact assessment must assess the availability of alternatives and the reasons why those alternatives have been set aside. In this week, we've had a debate about what the project teams view about those alternatives, and they've obviously relied on what the practice is in the UK. In the UK, well, it's not about the alternatives to the fundamentals of the project, it's about alternatives to the fine detail, the colour of the windows and all these kind of things. That, I think, is not in accordance with the legislation which Jersey introduced. And of course, what we find, we heard this week, that the site selection was the two sites which we've heard are offered much more favourably than this current one, were rejected on commercial grounds, particularly on the waterfront site where there was going to be, anticipated, the ministers believed we could not lose the capital gains that the states may be making. Because of that, they ruled out those sites. Now that to me brings in, I believe, it means that non-planning considerations were introduced into a planning decision, which I think is contrary to the planning and building law. So we have that situation where the statutory minimum doesn't comply, and I think the risks of going ahead on that basis are just simply too great. Now, other juries, now looking at our planning department, I very suspect, I know most of them well, they don't have the ability to make independent assessments of environmental impact assessment, and I really have a doubt whether those impact assessments that we've kind of parachuted in really can be based upon the Jersey experience and what life is like living in the Channel Islands. I don't think so. And I would feel much more comfortable if there was an independent review of them. And I think really I'd be strongly recommending that should happen if this project is to go ahead. Now we've heard about the Rochdale envelope, which clearly relies on these parameters which I've complained about being modified and changed later in the date. But obviously in the UK, except what we're told, this seems to be normal in the UK. You've got the Infrastructure Commission, you know, the great big HS2 projects and all that. This is what the rules are. But in a small island, I don't believe this is appropriate. I was part of the civil servants team that actually, I led that team in producing the Planning and Building Law, 2002. And I remember it well, the work we did, talking to the other islands, the other Crown jurisdictions. And we did include outline applications under Article 9 and also something relating to conditions in Article 23, as Mr. Dunn, I think, referred to earlier. That was because in the dim and distant past, Jersey didn't have this separation at planning stage between the various stages. But I do not believe it was ever intended by the legislators and the lawmakers that process will be used in the way it is now. We're being told we've got virtually no design particulars, they're left out entirely, and we're relying on what is a schedule of parameters, which I submit, sir, has not even been advertised, not even been openly discussed, not even been subject to consultation. I cannot see. I think that I really do feel for the planning department. They've been put in an impossible position here, and for that to happen, two parts of the states. We've got the Property Services Agency who are actually pushing ahead, and I'm hearing great inconsistency between the planning officers' views and what the project team are doing. This cannot be right in a small island. Something has gone badly wrong. We all have to work to the rules. Me as a private person, a private developer, and the state. Once we start throwing the rules out, I think we're in real trouble. So I think it's not appropriate, as I say. The example of the incinerator has been quoted. I think it is not, and I'm not going to repeat what was said there, I don't see that as a... I invite you, sir, and this is for you, sir, I say this with the greatest respect. I do not believe you will find, we've had a lot of evidence produced by the council for the UK, for the applicant, citing UK law precedents for the Rochdale principle. I don't believe there's any precedents in the Jersey law, and I invite you, sir, that if you are minded to go ahead and recommend permission on this basis, that you first of all take independent legal advice, that's Jersey advice from Jersey lawyers who experience the Channel Islands law about whether it is right that approach that's based on UK precedents is applied in a Jersey context of the planning and building law. I read the planning and building law again yesterday. The sections, the articles in there are very slim, the ones that the applicant is writing. There's not much detail. I even read the report that went to the States, which accompanied the report, which I know the court would look at. There wasn't anything in there to support this. And I think the fact that the UK has got extensive ministerial government circulars and we've got nothing on this subject, I think, so I invite you, sir, if you're minded to go ahead with a recommendation, please, I respectfully ask you to check that out. I think I've spoken about the disagreement between the planning department. I think almost we're in the Emperor's New Clothes situation here, where I find it really, I feel I must be on a different planet. Having lived in Jersey, the Channel Islands are absolutely different. The character of the place is different. When I'm asked to accept that what we have here, the application, is going to be an improvement to the urban fabric, and in keeping with the character. I mean, sir, I just feel, like, the little boy, and I'm being faced with all this enormous pressure and money spent, and saying, this is good, this is good, this is good, you've got to have it. But the Emperor's got no clothes. It isn't real. And I'm thinking, how are ordinary Jersey people going, what do they think? And here I am sitting here, and as a former politician, I've been both sides of the fence, not just a professional civil servant, but also a member of the public, which understands the islands. And a native, a Londoner who came here, is fell in love with the islands. The Jersey Architectural Commission, I just don't understand why we seem to have no we've got discrepancies there between what's on the record and what's being said. That's why we set up this body. We should be listening to advice. We've heard it said, Mr. Glover said, well, look, most people in the island are saying, get on with it. We have no choice. That's respectfully, I don't believe that's an argument for going ahead with a bad, failed scheme. That's not good enough. Everybody in Jersey wants real quality hospitals. And the people are, and you've probably picked up, sir, political context, those of us who live here. We know how our government has gone. When I was a civil servant, we had very close engagement. We had committees, we had people who were in touch with the people. This sort of situation would never have occurred. And now we have a situation where people are fed up with the states, they're unhappy with the project, they're unhappy with the costs, they're scared stiff, they're unhappy with the risk, and they're being told there's no alternatives. So I think, sir, please, I've been very impressed with the process you've run so far, and I've said to people said, how's it going? I said the inquiry process is working. Open, transparent, so 4 marks for what I've seen so far. You are the safeguard. Now, we've heard about this state's decision. The earlier witness there spoke about, and Chris Taylor spoke about. I've had some experience of states planning debates, and things that have gone wrong in the planning system. I used to have to function as a troubleshooter where things went wrong. And under state's rules, individual members can bring propositions, including on planning matters. they can only request ministers. There are numerous test cases in Jersey law and the Royal Court that shows that the planning decision maker is not entitled in law to substitute a decision of the states for its own independent judgment. Numerous cases. And I think that's a well-established principle, and I think that's something that's probably different in the UK. So we've had, and also I know as well, the history of states planning debates is appalling. I'll quote you a couple. Nobody could have failed to notice the road going right the way through St Heliers waterfront, destroying and making life difficult for the development of that waterfront. That was a state's debate political decision. There are other disasters, land reclamation's too far and so on. And the reason, because those debates take place, in my experience, with no planning officers present, no advice, and bring in any extraneous political factors, not land use planning factors that are set out in the planning law clearly as to what the scope is and what it's not. No. The states freely run and we get decisions. So I think, sir, yes, that decision has to be taken into account, but I think it needs to have an independent evaluation. So I'm nearly there, sir. I'm pleased to know. As I said here, I was considering, for example, go down to a minutiae level. When I was a politician, I had to help lots of people with third-party appeals, people who were concerned about the effects on application around them. I was particularly struck by the gentleman who gave evidence from the flats in Newgate Street. And I was really felt for him that here he is, this scale and mass of this building that's being imposed. And you rightfully raised queries, and I was delighted, sir, that you asked those questions about, what about how will I be able to assess the damage if there's no, if I haven't got a design to look at? But I thought the big point here, we're in a situation, and I'm going to re-emphasise the point, that if this goes ahead on this basis, that gentleman will have his rights of appeal and rights that, he doesn't have in the UK. It's a difference in Jersey law, because Jersey's politicians and its law is that residents have an equal right, equal status on planning decisions to the developers. That's not the case in the UK, it is in Jersey, and it's a very important provision, and therefore I think that, and clearly by accident of procedure, because it's been referred to this inquiry, sir, he would not have those rights. And I think that's really unfair. Instead of that, what it's going to be dependent upon is have faith, rely on the parameters, rely on the use of planning conditions, which you're going to talk about tomorrow. And I don't think, I'm not sure I'll be able to make it tomorrow, sir, but one thing I'm certainly I would want to know if I am, how can you enforce those conditions? What's the procedure? I know as a civil servant how difficult it is to enforce planning decisions. Mostly they don't get enforced. What do people do? Serve notice, and then you've got to go to the court and you've got to make your case. And then what if they don't do it? You have to go back to court. And then ultimately, and I think my reading of the law is that if there's a breach of condition, the states have got the power to step in and recover and remedy it and recover the cost. Just think that here. I'm sure this wouldn't have to happen, but that's the route we're going. The planning conditions process and the enforcement of them, I don't believe, sir, is designed to deal with this type of Rochdale-type application. I think that really is highly inappropriate. Now, Nelius, considering I do think that the decision has to recognise the social conditions of Jersey. It's very sad, this, and I've seen it change over 40 years, and it does upset me that we've become a very divided community. 40% around of our people live in St Helier in the urban area. The overcrowding and bad housing conditions is rife. The traffic, you've probably seen, sir, just go out the door and see what happens. We've got no traffic management in this island at all. Town residents have to suffer an environment where there's contamination, air quality. I think there's lots of scientific reports where they're well over the levels of the EU levels, toxic levels of all those pollutants that come from vehicles. That's the conditions. And what we're doing here, and of course this area of town is one of the most disadvantaged in Kensington Place in that area. It's small, you know, cost of property means that people are very difficult to access quality housing. But we need essential workers, we need people in that sort of social group. But what are we doing to them by imposing such a scheme upon them? So it's scary, whereas the alternative is just so much better. Look, my personal preference for the Wolfront, because I've long thought that this would bring life, a real function, and with the ability of spending £500 million, we could do a fantastic scheme which would be really fabulous for the island. And we could try and sort out some of the problems in the Waterfront and the master plan that I know, sir, I believe you as in previous inquiry pointed out. But I'm not wedded on that. I mean, either way, we learnt there are several sites, and this evidence has come out again and again and again, all of which rank better than this one. And we've kind of ended up with a Hobson's choice. I ask you, please, sir, please, I'm sure, think carefully before you recommend this. One last thing, waste management. When I read the application details, 77,000 cubic metres, and then I listened to the evidence yesterday, 37,000 I heard. I thought, I must have made a mistake here, am I going off the wall? You know, and I checked it back. Well, it's 37,000 or 35,000 for 2 years. So that's 70-odd thousand cubic metres of waste. And if, obviously, I'm assuming that nobody would propose that all the waste is processed on site. It's going to have to be shipped off. Well, on a 10-ton lorry, that means 7,700 10-ton vehicle movements over 2 years, in and out of this area. Wow. I remember other issues of land that came up during land reclamation sites. That is potentially horrendous. And I haven't not even picked up. And then there's the effects on the Opera House. I almost certainly the Opera House would have been demolished. If we'd have been in the UK, it wouldn't have survived. It would have gone under the developer's hammer, under the Rochdale envelope or what have you. It's a unique survivor. The states have spent money to do it. It's well loved in the island.
Can I have to ask you to draw to a close?
Okay, I'm nearly there, so I'm on page 15 of 16.
Just stop.
Okay.
You're repeating what everybody else has been saying.
Sorry, okay, thank you. I will therefore stop.
Thank you, that's appreciated. We've got to 1 o'clock, and I've got 2 more speakers.